Creator energy has us in the winner's circle every time. Our perceptions of success or gain can give us a feeling of elation and motivation. We set and achieve a goal, or by seeming chance, have an opportunity that lands in our lap. We feel like it's a win. However small or large, we smile, may have expected it, or may even celebrate, but the win compels us on. When we experience a snag or a challenge, we can feel deflated. When the challenge feels overwhelming or insurmountable, we can often see it as a loss or the wrong direction or path. It may even feel like a signal to abandon it. This is when we must go in, self-reflect, and ask our higher self, our spirit, is this challenge my hint to move on? Or is this an overcoming? Only you and your spirit can answer the question. In this, it is personal. That losing feeling, once explored, felt, or acknowledged, is actually a win either way. If your choice is not to pursue that challenge, but to go another direction that feels better, it's a redirection with more to explore within the self, and we grow. That's a win. If your choice is to pursue that challenge, your spirit has directed you to dig in and overcome. Often, such a challenge becomes a contest with oneself of determination, and will that inevitably bolster our resolve, sometimes seemingly against all odds. Either way, losing or winning is winning in this construct. It is meant to challenge our growth and connection and trust in spirit and our almighty prime creator. Looked at this way, obstacles become opportunities for growth and change. We have then become active participants in change, which is always inevitable. But in having offered ourself, we change with it. We discover there is no losing, only winning. Gratitude abounds always for the miracle of spirit and our living a life that is blessed with our connection to Prime Creator. And so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I have here a progress report for orsja.org from 2019 to 2025. Grand Jury Trial number 74, the Grand Jury Trial for the Oregon Department of Education and Law Enforcement, the 6th Grand Jury. 08/01/2023, show 136 on the Oregon Statewide Jural Assembly. Actions and accomplishments in review. Formed a First Amendment Assembly as an Article 1, Section 1 Social Compact, 2018. Formed petitions for redress of grievance versus Kate Brown, Jeff Merkley, Ron Wyden, and Suzanne Bonabici. 2021. Formed a grand jury pool, now over several hundred. We called our first grand jury when we were 45, 2021. Applied once, notarized, and immediately for the second time with an explanation to the Oregon Supreme Court for an apostille, as Washington, D.C. is foreign to our court, our assembly, and to the people. It was denied. We applied, notarized again in 2024 with the Secretary of State's office. Denied again, 2025. I'm going to add one here. We also submitted our paperwork to the Bureau of Western Hemisphere Affairs, to the United States Secretary of State's office for Oregon, the state among the several states. We called out the Oregon Supreme Court Justice Martha Walters, She acquiesced and retired at the end of 2022. We're 3 years without a rebuttal on that one. We called out her successor, Megan Flynn, who has also acquiesced. Time for another contract there. 2 letters written by each of 2 of our members to Nancy Cozine, Oregon Trial Court Administrator, requesting an appointment with her and enumerating why by each of us a few months apart. These letters' requests were never responded to, nor were request appointments granted. Trial court administrators is an Article 7 amended de facto service for 115 years, 2025. 6 of us from our court, which included our marshals and our deputy marshal, alerted Nancy Cozine that we would be coming to meet with her. We were scanned into the building when one of her marshals came down to tell us she was not available. No persuading or lengthy insistence offered by us for a meeting with her was granted, present or future. She acquiesced. Current 2025. We provided the then Treasury Secretary Tobias Reed with copies of our documents regarding due process violations regarding Kate Brown. We gave the documents to Reed's deputy treasurer, Michael Kaplan, who said he would give them to Tobias Reed. Both acquiesced. Tobias Reed became the Secretary of State, and Michael Kaplan became Deputy Secretary of State. 2025. History shows Richard Vail, then Cheryl Myers, and currently Michael Kaplan, all 3 Deputy Secretaries of State, failed in fulfilling any of our requests, and each one acquiesced. Current 2025. The following points of discussion and activity involve more recent claims to the de jure jurisdiction versus de facto color of law. In our search for an Article 3 court, our court clerk had an issue to resolve. Through a series of events, Richard Molmer, trial court administrator for Washington County, signed for both courts, which are apparently in one building with no defining indication that there is, in fact, an Article 3 court. There was much to be found, and it was strange and curious with regards to the county court. State rented space from the county. Richard Molmer signed a change to a jure court, but then had the case dismissed through failure and lack of follow through. Then there was no failure and there was no lack of follow through. The next step is to file a due process violation with Shelley Hoffman, DAS Risk Management. Our court appeared on behalf of one of our assembly members to talk with Police Chief Kosmicki, Newburgh, and his associate on Yamhill County, and to educate them and attempt to engage regarding their poor conduct. Our fellow assembly member had been stalked, arrested, jailed, strip searched for not complying with driver's license and DMV license. Only bail would release her. She has been stalked and arrested on a phony bench warrant. Subsequent to that, and has now accrued significant fines for failure to appear on each charge, despite her lawfully responding to each charge and knowing we are not in that jurisdiction of their de facto court. I might not mention it here, but I'm going to say it now. The Fifth Appellate Court and SCOTUS, I just found out, but in 2024 made the decision that these courts cannot function like they are. They don't have Amendment 7, and men and women require Amendment 7. So says the Fifth and SCOTUS. We've been saying that for years. Nearly a year later, our court appeared again on her behalf with a claim of cognizance, but was refused by attorney Jean Schilbeck and by municipal court judge Larry Blake to allow her to file her paperwork into the court record prior to her hearing. I was there. In this and each of the cases involving travel in this category, our court has issued a claim of cognizance in the form of a certiorari placita on behalf of each of the accused or ticketed. In each case, we offer a third-party interdiction wherein lawfully the man or woman charged is removed from the de facto color of law jurisdiction, and our court of record ideally intervenes on his or her behalf. There has been 9 individuals in our assembly that have been detained or arrested, or at least once due to travel-related stops within the last year and a half. And in each case, we have had varying responses. It is the varying responses that are notable. One case was a stop when the officer said, "You're free to go." Most often fines, some significant as to punish, are imposed. Jail time. In all cases, the Leos believe their statutes and ordinances are the law, and they have what they are doing is legal, just and necessary. From our perspective, we are constitutionally free to travel the highways, byways, and waterways of our nation unencumbered, uninterrupted, or charged financially or otherwise. To date, ORSJA has called 9 grand juries, all with presentments and true bills. Richard Mulmer told me in 2016 that there was no way that there would be a Washington County grand jury unless the DA said so. Well, we did one for the whole state and didn't get permission from one district attorney. Completely legit, Richard. To date, 10 verdicts from 10 petite juries from our Article 3, Amendment 7, Original Jurisdiction, Article 7, Civilian Common Law Court of Record of Article 1, Section 1, a de jure social compact. Notified the U.S. DOJ, the U.S. Marshal Service, the U.S. Marine Corps, the FBI, U.S. Federal District Courts of Eugene and Portland, and they all acquiesced. Informed the state of Oregon, aka all caps state of Oregon, multiple times, and they acquiesced multiple times. Held grand jury and petite jury trials on Kate Brown, the governor, from 2015 to 2023. Also on Ron Wyden, Jeff Merkley, Suzanne Bonamici, with verdicts of all three. They have no honor, and they may not hold a position of trust. Held grand and petite trials on the Oregon legislature 2021, 2022. 89 out of 90 for breaking their oath and having no honor and being unfit for a position of trust. January 21st, 2021. We served 29 senators. One had died on Article 7 amended. They all acquiesced. We served 17 senators on their violation of the Second Amendment, and they all acquiesced. We notified 17 senators and 36 sheriffs on 2A, and they acquiesced. We notified 38 attorneys, district attorneys, JAG, and attorney general, prosecutors, on the convictions of Kate Brown, Ron Wyden, Jeff Merkley, and Suzanne Bonamici, and they acquiesced. We filed 3 amicus curiae briefs into the U.S. Federal District Court in Eugene with 3 witnesses in the audience, and the courtroom was cleared and the case was never called again. 3 years in holding. Filed a claim of cognizance with the DA for Marion County, Paige Clarkson, and they removed the arrest warrant from Richard Koenig. Filed a claim of cognizance for all Oregonians and several specific ones to 3 courts that stopped their actions. Grand juries on Oregon Health Authority and OHSU et al., naming 42 individuals, all of which have been signed, sealed, stamped, witness, proof of service, and published. And they acquiesced. We served a writ of habeas corpus ad subjudiendum on Ken, Mike, and Corey at the Department of Corrections on behalf of David Coolidge, and they failed. Grand jury trial, service of same. Our civilian common law court of record maintains a jury pool of several hundred for over 4 years. 9 grand juries have been called, and 9 have appeared and took action. Our Oregon Article 3, Amendment 7 Civilian Common Law Court of Record has met as an ongoing court for 6.75 years with 10 jury verdicts. No other civilian common law court of record that we know has implemented Ex parte Milligan, nullified martial law, Lieber Code, and FEMA, implementing Article 3, Amendment 7. Just exactly what the 5th and SCOTUS said is required and suggested. Maintained our Article 1, Section 1 social compact, actively involved for almost 7 years. Still standing. Hold consistent weekly meetings every Monday evening. Action committee every Monday morning. Never missed. Printed 2 major flyers and distributed them. We're also publishing the Oregon Desiree Journal. We've had 2 on the streets and a 3rd one coming. And if you go to www.orsja.org, you'll find them there. I think it opens on them. And we mailed those to a little over 1,000 important places on Oregon. like 300 libraries. We produced a 32-page travel kit, and it's available for donations, or you can print it yourself. Printed free-to-go cards for fellow travelers that were received by 3 detectives. I was there for the Oregon State Police without rebuttal, and I notified them just last month. Hey guys, you've had it for well over 90 days and you haven't rebutted. I guess you accept them, right? We've published over 200 half-hour cable TV shows on 3 cable channels in Portland and published over 300 YouTube and Brighteon videos. The 36 sheriffs on Oregon have failed to properly occupy the office of sheriff. They are without their required bona fides, oath and bondability, ORS 206, DPSST, county recorder, and HR. The Oregon State Police Superintendent Cotting is without proper bona fides. The Oregon National Guard's General is without proper bona fides. Began quarterly newspaper. I told you a bit about that. Developed a certificate of oath for sheriffs. It's not what has to be, but it's what is needed to be included. The oath for sheriff and for other officers. And we demand their oath incorporate both constitutions circa 1859 with the laws of nature and nature's God. Continually hold local law enforcement to their required and proper oath of office for the people rather than for the corporation. Despite several conversations and face-to-face meetings, they are all acquiescing, and instead of complying with the de jure that they know is lawful and legitimate, they continue to comply with the de facto, the illegal and illegitimate Oregon State Bar and Article 7 amended. And I yield.
Hi, I'm Eric Dover with the Oregon Statewide Journal Assembly, and I have some messages for the Oregon sheriffs. Where are sheriffs? Our Article 3, Amendment 7 Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system, rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are sheriffs? It is significant that they take a proper oath to the Constitution, circa 1859, with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead with his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.